Hello, everyone. I hope everyone's doing well. This is Brian Khan with another episode to help you pass the baby bar exam. So, in this particular segment, I wanted to make this video for those who didn't pass the baby bar on their first try. Now, if you're somebody who has failed the baby bar for the first time, I want you to know that it is a test prior to June 2024 administration. The past two administrations, if you look at the bar website, the passing score or the passing percentage of this test was around 13%. If you don't believe me, you can go to the bar website and take a look at it for yourself. Also, if you've seen any of my previous videos, I took the baby bar exam 10 years ago and I failed the exam. However, I never gave up, even though my life circumstances were difficult. I didn't know at the time whether or not I could continue with my law studies. But after 10 years, when the opportune time came back to me, I decided to take the test. And I took it this year in June, and I ended up passing. Now, many people may scare you that this is a very difficult test, but I wanted to also give you some positive aspects of the baby bar exam so that you're not always hammered with so much negativity because negativity doesn't always work. So for this past 2024 June baby bar exam, those of you know may know, but they changed the format of the testing, meaning they used to test three subjects: criminal law, torts, and contracts, and one random essay, and then test you on 100 multiple choice questions. And this was the exam that I took 10 years ago. And just the other day, I went back and I found those essay questions and I double checked to see what I got 10 years ago when I failed the test. Is that I got 65, 65, 65, and a 60 on our contracts essay. So if my MBEs at the time were high enough, maybe I could have passed 10 years ago. But my MBEs at the time were like around 50%. So if you fail this test, I know your pain because I was there. Not only that, because of so much things happening in my life, I had to wait another 10 years for me to be eligible to take this test. I was always eligible after failing the first time, but at the time I lost my business. I lost my relationship with a girl that I was supposed to marry at the time. And my family relationships all fell apart. Not only that, just a bunch of things happened at the time. And even now, my life is not, so easygoing. I'm still facing a lot of difficulties that I won't mention on this video. But I just never gave up. And for this June 2024 administration, I prepared around, I would say, almost a year. I would say 9 to 10 months to be exact, because even though I kind of had all the black letter law in my memory, it was still not 100%. I forgot a lot of concepts. I had also realized that 10 years ago there were some legal concepts that I didn't fully comprehend. So during the past 9, 10 months prior to taking this test, I made sure to understand everything. Not only that, I made sure to memorize all the black letter law. So while I was thinking about what else I can do to help those that have failed this baby bar exam the first time, like I also have in the past, I thought that it'd be a good idea to go over some multiple choice questions that are available on the bar website. This is not just for people who has failed the baby bar for the first time. I think this may be a great resource for those who are planning to take this test test for the first time, or if you're somebody who are taking the test but are just totally lost and you don't know what to do. But that is understandable. That's understandable because I remember my first year in law school, I failed it 3 times, meaning most people graduate law school in 3 years. But for me, I went to a brick and mortar for about a year and 6 months, but they said that I wasn't smart enough. So they said, goodbye. You can't even come back to our brick and mortar school for another like 5 years. So as soon as that happened, I had to find another school to enroll myself because I really wanted to just, finish my law studies and get it over with. But another difficult hurdle came when I transferred to another school. The correct language wouldn't be transfer, it would be when I started over from the beginning. And I did 1 year at this distance learning unaccredited law school, and they said that I still wasn't good enough, that I wasn't smart enough. So here I was at the time. I did a year and 6 months at a brick and mortar. They said I wasn't good enough, and they kicked me out. And then I went to this new law school, which was primarily done online. And after a year, they said that I wasn't good enough. So they said you could either do another year, and that wouldn't be a guarantee either, or you can just give up. So after 2 years of 6 months of first year, repeating first year, I said, you know what, I'm going to do another year. So I did another year, and that was when I was eligible to take the baby bar exam, which was 10 years ago, and I failed, like I said before. So I understand because when during your first year, if you're new to this, unless you have like a family member, unless your father was a lawyer, your uncle, somebody in your family kind of knew what to do and kind of taught you, everything in your first year of law school will be just very confusing. And I don't think that has to do with whether or not you're smart or you're dumb. I don't think that's the correct answer here. I think what it is whether or not you know what to do. You know how to study for it. Like you know how to approach the test. I think unless you have that in you or somebody taught you, it is very difficult. You're going to be looking at things that you're not supposed to study. I mean, you're going to look at concepts that are irrelevant to you passing this exam. So, in more than many ways, you're going to have so many things working against you. And because I've been there, I understand. And that is why I'm creating all these videos so that if you're in my shoes 10 years ago, not knowing what to do, not having enough money to hire a tutor, I'm just making this content so that you can use these for your benefit. I'm making them free of charge. So if you're really in need of direction, you need somebody who can guide you through these tests, or you just don't know. You feel completely lost in your first year of law studies, or preparing for the baby bar, or you have failed the baby bar. I think that this video would be a great resource for you. So I know that I could just talk on and on about what you should do to prepare, how you should study for it. But since the testing format has completely changed, they got rid of the essay portion, and now you just have to do 100 multiple choice questions and get 70% of them right. I mean, if it's a curved score, they may lower it a little bit, but you know, ideally you want to get 70% or higher on this test. And also, to work through these tests, you could go through BarMax, which is the one that I used. It helped me pass the baby bar, or like what everyone else uses. You can use the AdaptiBar, but just having somebody that kind of they can kind of explain to you the thinking process behind getting to the right answer for these MBE questions for the baby bar, I thought maybe a good way to help you pass the test. And another good news is that for the June 2024 exam, the passing score, I'm talking about overall, and that includes like people who had to take it from the ABA, from correspondence law schools, distance learning law schools, out of state. The combined passing percentage score for the June administration was, I believe, around 33.3%. So that is a significant jump from the two administrations prior to the June one, which was like 13% overall. Now, if it's 13% pass rate, we're talking, you know, 1 out of 10, not really 2 out of 10. We're talking like in between one or two persons out of 10 people that passed this test that were eligible to go on with their second year of law studies. But, to tell you the good news, for this June one, the passage rate was 33.3 around percent around there. So we're talking like one or two persons that used to pass out of 10 to three persons, between 3 to 4. I would say it's less than 4, definitely, because even at my law school, I believe there were like 16 students who took it, and out of 16, 4 people passed. And out of 16, I believe like 3 or 4 people were repeat test takers, and the rest were first year law students. So that's like what, like almost a little bit better than 30%. So we're talking like 3 out of 10 people basically that were able to go on to their second year of law studies and get credit for their first year of law school. So again, this is not an easy test, but I'm not sure how the next test is going to be, because this past test in June, the passage rate was a little bit higher. So I can't foretell whether or not the passage rate will go down or lower. But just working with the June numbers, it has gotten, I wouldn't say easier, but they passed more percentage of students. And I would say this is comparable to the overall bar exam statistics, because I believe bar exam statistics, and I'm talking about like everything combined. You can correct me if I'm wrong, but the last time I checked was around 34%. So, I think they try to bring up the baby bar passage rate up to par with the regular bar exam passage rate, which is 34%, and this time was around 33% for the baby bar. So the chances of you passing this test has increased, it hasn't decreased. So don't get so down on yourself if you failed the exam. Just make sure to memorize the law, really understand the concepts. And some of these questions are tricky. They may seem to test one thing, but they test completely another. So make sure that you read carefully. And lastly, make sure you manage time, because this is a test of pressure. They pressure you, they give you a lot of time to finish reading, which is not easy, especially if you're not used to the surroundings and you go to a new place and you try to take something and you try to like ultra focus on something. That's not easy. So make sure that if you're practicing for these tests, that you're practicing under timed conditions, because there will be pressure. And I barely finished my exam in June because I didn't expect to be that pressure, to be honest. And you get about minute 30 per question, but it felt like minute 30 just flew by, for each question. And for some questions I had to read it like 3 or 4 times. It didn't click because I was so used to studying at home and just being at a different place. Prometric Center, I went to the one in Culver City, and just being there, and trying to just bring my ultra focus into this test. It wasn't easy, but somehow I managed to finish it and finish the second portion. And I didn't really feel good about it because I felt like the test was really difficult. It was definitely more difficult for the June one in comparison to practice MBE questions that I've done on BarMax. But when I got the score, I was excited. I passed the exam. So ever since then, I've been just trying to record myself and leaving some videos so that I could help more people who are in my shoes, so that you don't have to make the same mistake I made when I was a first year law student trying to pass this test to go on to the second year of law studies. So again, I thought that a great way to kind of help you if you fail the baby bar for the first time is to just kind of go over some of these MBE questions and kind of show you my process of thought, my process of thinking, kind of like you picking my brain, so that that how I arrived at each answer for each question, rather than me just talking without something for you to look at. And again, this practice exam is from 1980. And before I took a look, I was like, what, 1980? They tell you that it's not their standard practice to release any of the MBE questions, but they go, hey, this is from 1980 and this is something that we can share. So I've kind of looked at some of these questions, and I realized that they're not too different from what they're testing now. Maybe like the wording may be a little bit different, but the law that they're testing is still the same. So I thought that maybe if I take 7 or 8 sessions of just going over like 10 questions per video, then somebody who doesn't have the resources to hire a tutor or somebody who just doesn't know what to do in order to pass this exam can look at my video and hopefully you'll learn from my process of thinking, and hopefully for your next exam that these videos helped you so much that you're more confident and you're able to finally defeat this baby bar exam so that you can go on to your second year of law studies. So without further ado, let me just I'm not sure how many I can do because it's already been 21 minutes. Because intro is important. Maybe this is your first time, watching me. You haven't seen any other of my previous videos, so maybe I thought that I needed to explain who I am a little bit so that I can be more credible. That that I'm not somebody who hasn't been in your shoes, who hasn't had difficulty in life, just blabbering. I'm here because I've been in your shoes and I have passed this exam, albeit all these difficulties that I've had in my life. So let's just start with question number one. Okay, so I hope that when you're actually taking the test, that you don't have to read the directions because the timing is so important, and I wouldn't waste my time reading directions because you already know what to do. You have to answer questions. You're gonna get choices A, B, C, D, and from that you have to choose the best answer, right? So I wouldn't waste your time, my time, reading directions. I would just go right into it and attack it from number one, right? So let's look at number one. So Carl and Homer entered into a valid written contract under which Carl agreed to build a house on Homer's lot. Homer agreed to pay $150,000 for the house. The contract stated Homer's duty to pay shall not arise unless and until the house is constructed in full compliance with the attached specifications. Okay, so one person's building a house, other person's paying for the house, but there is a clause in the contract that says unless the house is constructed in full compliance with the attached specifications, the duty will not arise. The duty of payment will not arise, right? So that's kind of like a condition, but we haven't read through question number one. So let's look at what number one says. Assume that shortly after commencing performance, Carl called Homer and said that the half-inch rods for the foundation required in the specifications were in short supply, but that quarter-inch rods were readily available. Homer replied, "Go ahead and use the quarter inch. One day later, before Carl had bought or installed the rods, Homer called and stated that Carl must use the half-inch rods. Carl refused to do so. The best analysis for the party's legal rights is okay, so let's look at this question, right? So a party says quarter-inch rods are not available, right? Or in short supply. But I have half inch rods that were required are in short supply. But then I have quarter-inch rods available. And, Carl called and Homer replied, go ahead and use a quarter-inch. As soon as you look at this, some legal concepts and contracts should pop up in your head. Number one is they already had a contract, right? But they were trying to modify this contract. And what do we know about modification? Now, modification, when it comes to UCC or sale of goods, modification can happen as long as there's good faith between the parties, right? For contracts that are not under the UCC, what do you need for a modification? A modification for non-UCC contracts require a consideration. Now, when you look at this fact pattern, I don't see a consideration here, right? A party called and said, I don't have half inch, I have quarter inch, you know, and he was attempting to modify this contract. So let's finish reading and see what they're asking. But that's the first thing that popped into my head. Modification, contract modification. When it's UCC, only good faith. When it's service, requires a consideration between the parties. Okay, so one day later, Carl had bought or installed the rods, Homer called and stated that Carl must use the half-inch rods. Carl refused to do so. Right. So when Homer said, go ahead and use the quarter inch, what happened there? There was a waiver, right? A waiver by Homer saying, hey, you're supposed to use half-inch rods for the foundation, but since you have quarter inch, go ahead and just use the quarter inch. So the other side, Carl had a duty to use the half inch, but Homer waived that duty and said, just go ahead and use the quarter inch. But the problem arises here, and what is that problem? The problem is one day later, before Carl had bought or installed the rods, Homer called and stated that Carl must use the half-inch rods. So what happened here? There was a retraction, right? He retracted the waiver when he said use a quarter inch, right? But before Carl had bought or installed the rods, Homer called and stated that Carl must use the half-inch rod. So what are they asking here? They're asking whether or not this waiver was valid, right? I mean, this retraction of the waiver, was that valid? Now, one thing you have to know about retraction of the waiver is if the other party, right, substantially relied on your waiver, then you cannot retract your waiver. Meaning, you know how the fact pattern here says, before Carl had bought or installed the rods. That's the main thing here. Because if it was after Carl had bought or installed the rods, then this retraction wouldn't be valid. He cannot retract it if the other party bought and installed the rods relying on the waiver saying, hey, go ahead and use the quarter inch. But instead, what happened in this case is that instead of relying on that waiver, the fact pattern tells you just straight up before Carl had bought or installed the rods. So Carl did not rely on that waiver by Homer telling him to use the quarter inch, correct? So was this waiver valid? Yes, because there was no reliance on his waiver. So knowing that, let's look at A, B, C, D and see which one's the right answer, right? Homer waived his right to have half-inch steel and his waiver cannot be retracted. That is wrong because I just told you, as long as the other party did not substantially rely on your waiver, he can still retract that waiver. So A is wrong, right? Homer and Carl modified their contract, and Carl may use quarter-inch rods. Well, I told you in the beginning that when it's like a contract, not for a sale of goods, but this is a contract, a common law contract in which each party is bargaining for a service, more like an installation job, to use the quarter inch or the half inch. So because this is an installation job, what do you need? You need a consideration, right? Because it's a services contract. So because this is not a sale of goods, this is a services contract, that modification wouldn't be valid, but you can still waiver as long as the other party doesn't rely on your waiver if you're trying to later on retract that waiver. So B is wrong. Let's look at C. Homer waived his right to have half-inch rods, but he has retracted the waiver so that Carl must use half-inch rods. So did Homer waive his right to have half-inch rods? Yeah, but he has retracted the waiver so that Carl must use half-inch rod. Well, that sounds pretty good, you know, because he waived his right to have half-inch, but he has retracted the waiver so that Carl must use half-inch rods. Now, again, he cannot retract the waiver if the other party relied on that first waiver and then and try to say I totally relied on what you said. Then you have to go by with your first waiver. But that did not happen because he did not buy or install the rods, right? So he was Homer when he waived his right, and since the other party did not significantly rely on his first waiver, he was allowed to retract the waiver, so Carl must use half-inch rods. You get it? So C is probably the right answer, but I always make sure to read all four because this is a test that's going to test you on, picking the best answer. Sometimes the answers may not be so so obvious, right? So let's look at D. Homer's statement, go ahead and use the quarter inch, is not effective either as a modification or waiver because Homer did not expressly agree to modify or waive. That's like kind of like a confusing answer, right? Because there was a waiver, right? And he did expressly waive, not a modification, but a waive. So because I already told you this is not a modification, when they talk about or D talks about modifying, this is a wrong answer. So correct answer would be C for this question number one. And this is not an easy question. I would say like on a scale of like 1 to 5, 1 being the easiest and 5 being the hardest, I would say this is a 5. And I am sure they purposely put this on number 1 to kind of trick you out, psych you out, so sort of kind of to like, you know, throw you off. So don't like fall into this trap. Even if you don't really understand number 1, make sure to finish your test and go on to number 2 with full strength, right? So let's not look at number 2. Assume that during his vacation, Homer voluntarily spent 2 days helping Carl construct the house. At the end of the second day, Carl mentioned the fact that he had an antique weather vane, and Homer said he would like to buy it. Carl stated, You've already done enough for me. I'll give the weather vane to you and install it tomorrow. Homer said, Thanks a lot. When Carl refused to deliver or install the weather vane, Homer sued. The principal question for the court is whether, okay, so you know about consideration, right? Consideration is a bargain for exchange in which each party suffers a detriment, forbearance of a promise, right? Kind of like when you're trying to buy a refrigerator and one party loses the refrigerator and the other party ends up paying and they end up losing their money, right? And each party is bargaining for something. It's an exchange of bargain. So this question is testing you whether or not you understand the concept of consideration, and also whether or not you understand that past consideration is not valid consideration. So here, Homer voluntarily spent 2 days helping Carl construct the house, right? So he did something. Homer voluntarily spent 2 days helping Carl construct the house. And Carl mentioned the fact that he had an antique weather vane, and Homer said he would like to buy it, right? And Carl said, You've done enough. I'll give you the weather vane to you and install it tomorrow. Thanks a lot, Homer said. But when Carl refused to deliver or install the weather vane, Homer sued. Can Homer sue, right? Well, whether or not Homer can sue would depend on whether this was a valid contract, whether or not there was an offer, whether or not there was an acceptance, whether or not, most importantly, what this question is testing you on is whether or not there was a consideration. And obviously, you got to go through the defenses of enforcement and all that. But this question is obvious that they're testing you on your knowledge of consideration. So the question is, it tells you that the principal question for the court is whether, right? Homer's voluntary work was sufficient consideration. There you go. For Carl's promise to give Homer the weather vane, right? Well, a party here can argue, Homer can argue, I spent 2 days helping Carl construct the house. But what do we know about past consideration? Past consideration is not valid consideration. It's not valid bargain for exchange, right? So that's if Homer is trying to argue that, saying his 2 days spent on helping Carl was valid, that was not valid consideration, right? So A is the answer. You don't even have to look at B, C, or D for, but we have to get into good habits. So let's just look at them. Carl's statement about the weather vane is enforceable as an oral modification of a written contract. Modification, we're talking about consideration here. As soon as you read number 2 question, you should know that this is asking you for consideration. That's wrong. Pro evidence, we're not talking about pro evidence here, right? I mean, that's way off. That's not even relevant. Let's look at D. Carl's statement about the weather vane constituted a promise. Are we talking about promise here? We're talking about whether there was an enforceable contract, right? So whether or not parole evidence, whether or not there was a promise, that doesn't matter because they're testing you on whether or not you know what is required for a valid contract. And consideration is something that is needed, right? And A answers that question. So the correct answer would be A. Let's look at number three. Assume that neither the written agreement nor the specifications mention the size of the water heater to be installed. Carl installed a 20-gallon heater. The size of the house reasonably required one of at least 40 gallons. After the house was completed, Homer noticed the size of the water heater and said he would not pay the contract price. Carl is now entitled to recover from Homer what? Okay, so you know that this contract, they told you in the beginning that Carl and Homer entered into a valid written contract to build a house, right? But now they're talking about a water heater, whether it was a 20-gallon water heater, whether it was a 40-gallon water heater, whether or not installing a 20-gallon water heater when it reasonably required a 40-gallon water heater, was that a substantial performance or material breach, right? If it was material breach, then that would be a breach, and he wouldn't have to pay, even for uh, you know, the contract price minus whatever damages that he suffered, right? So the crux of this question would be, it was $150,000 contract for the entire house, right? And he installed a 20-gallon heater instead of a 40-gallon heater. Would that be a material breach after building the entire house? Probably not. If he didn't build a house and then if he installed a 20-gallon water heater instead of a 40-gallon, then that would definitely be a breach. But because this is a part of a $150,000 house contract, that's like a small portion of it, right? And installing a 20-gallon instead of 40 wouldn't be a material breach. Rather, it would probably be a substantial performance in which one party will be able to ask for a contract price minus damages for breach. So we would probably have to look for an answer that is similar to what I just said. Now, Carl is entitled to recover from Homer. Homer, number A. A, nothing because his breach allows Homer to treat the contract as discharged. No, because this was not, I just told you, this is not a material breach. It's a substantial performance. So A is wrong. The full contract price, because the agreement did not specify the size of the water heater. Well, it was reasonable to install a 40-gallon, but the other party, Carl, installed a 20-gallon, right? So there was some loss there. There was a damage on the part of Carl, right? I mean, Homer, right? He suffered a damage because he was supposed to get 40, reasonable, but he got a 20. So he wouldn't have to pay the full contract price, right? Because there was a substantial performance, even though it's not a material breach. So it would be full contract price minus the damages for breach. So B is wrong. Let's look at C. The full contract price because he substantially performed the contract. Well, he substantially performed, but if he substantially performed, then he would be eligible to receive the damages, the contract price minus the damages for breach. So C is wrong. Let's look at D. The full contract price minus Homer's damages for breach of Carl's implied obligation to install a heater of the size reasonably required. That's the right answer, right? Because the D is saying he would be able to get full contract price, but that would be minus after minus subtracting his damages for Carl's breach because there was an implied obligation to install a heater that was reasonably required. So D is right, and it's the best answer. It's obvious. Let's look at 4. Assume that the contract provided that Homer's payment for the house would be due upon receipt of the architect's certification that the house was built in accordance with the specifications. The architect refused to issue such certification because the fireplace was not constructed in a workmanlike manner as required by the specifications. Homer refused to pay the contract price. So what happened here? So there was a condition, right? There was a condition, and what was this condition? The condition was that unless the architect issued a certification saying everything was built in accordance, with the specifications, Homer wouldn't have to pay, right? Unless, obviously, if Homer waivers that requirement. But there's no mention of wavering in this fact pattern. So that condition is good, right? But here, architect ended up not not certifying because his argument was that fireplace was not constructed in a workmanlike manner as required by the specifications. See, if you do a lot of these questions, you'll see fact patterns that are very similar to this, right? And they usually ask this question. They ask whether or not this certification by the architect was made in good faith, right? Because for something like this, like a architect's, it's not subjective. I would more say like objective decision to certify if it was made in bad faith. For example, a lot of questions will give you like he didn't certify because he believed that the cost was like $20,000 over. The cost was like $30,000 over. That would be bad faith, right? And if that certification or refusal to certify was made in bad faith, then Homer would not have an argument because it was made in bad faith. And Carl can argue, hey, that certification was not made because the architect was not acting in good faith, right? And he can try to enforce the contract. But here, architect refused because the fireplace was not constructed in a workmanlike manner as required by the specifications. And it seems like the architect in this case didn't certify out of good faith, right? So what does that mean? That means Homer doesn't have to pay the contract price, right? So what's the question? If Carl insists that the fireplace was constructed in a workmanlike manner and sues for the full contract price, who will prevail? Obviously not him, because it was not up to him to argue that the fireplace was constructed in a workmanlike manner. It was in the contract, right? There was a condition saying unless architect approves, I don't have to pay. So you're gonna look for something along the lines of what I just said, right? So let's look at A. Homer, unless Carl proves that other architects would have been satisfied with the fireplace. Well, where in this condition in the contract say that you can get other architects, you know, As long as if other architects other than the one mentioned in the contracts, if they're happy, then this contract would have been satisfied. There's no mentioning of that. So this is irrelevant. A is wrong. Let's look at B. Homer. If Homer proved the architect's refusal was in good faith. Right, we talked about good faith, right? If the architect's argument saying that this is not going to be certified because it was expensive, that would be in bad faith. If it was in bad faith, then Carl would have an argument, saying we should, judge, please enforce this contract. But here, as long as that refusal to certify was made in good faith, right? Homer could refuse to pay unless that condition is satisfied, and it wasn't satisfied. So B is right answer. But let's look at C. Carl. Unless Homer proves the architect's refusal to certify was both reasonable and in good faith. Well, the the condition here, there is no reasonableness standard here. The standard that they use here is good faith. So the fact that C uses both reasonable and good faith is wrong because it is only the standard of good faith. So C is wrong. Let's look at D. Carl. If Carl proves that the fireplace was constructed in a workmanlike manner. Even if Carl proves that the fireplace was constructed in a good manner, that's not going to satisfy the condition which was written in the contract. The condition was for the architect to prove that, certify that the fireplace was constructed in a workmanlike manner, not Carl. So D is wrong too. So what's the right answer, as we said, as I've said? It's B, Homer, if Homer proved the architect's refusal was in good faith. All right, so let's look at number 5 now. Okay, so assume that the day after entering into a contract with Homer, Carl borrowed 150,000 from bank and assigned to bank Carl's rights against Homer. Okay, so what happened here? There was an assignment, right? Carl borrows $150,000 from bank, right? And he's assigning his rights, the rights against Homer, with the bank, right? Bank promptly notified Homer of the assignment. Carl performed 75% of the work and then abandoned the job. Which of the following is the most accurate statement of the rights of Bank and Homer? Okay, so there was an assignment, right? What was this assignment? He was supposed to receive, right? He was supposed to do the job, and he was supposed to receive money from Homer. But that money, since he assigned that to the bank, that money is owed to the bank instead of Carl. But what happened here? Carl performed 75% of the work, and then he abandoned the job. So even though this is like a common sense thing, so Carl performed 75%. He didn't do 100% of the job. Can the bank ask Homer for the 100% of the job? No. Because the person who assigned it, or the assignor, was Carl, and the assignee, who is the bank, the assignor did not fulfill his obligations, which was doing 100% of the work, right? And the obligor, who is Homer in this case, wouldn't have to pay the full contract price. He would have to pay 75, right? But he suffered a damage of not getting, 25 more percent more of the work that he was promised to receive. So knowing this, right? Let's look at A, B, C, D. A. So question is, which of the following is the most accurate statement on the rights of Bank and Homer? Bank has no rights against Homer because construction contracts are not assignable. That is wrong. Unless there is like a material hardship, right? Contracts are generally assignable, right? Unless the other party will suffer like a material detriment because of the assignment, generally it's assignable. So A is wrong. B, bank having accepted the assignment from Carl must arrange for completion of the contract and cannot recover anything until the work is completed. No. Here the bank doesn't have to arrange for completion, right? And they can recover, just not, 100%, you know. But the fact that they have to arrange for completion kind of doesn't, the wording doesn't really, I don't know, it doesn't sound right. So let's look at C. Bank may recover the reasonable value of the work performed by Carl, minus damages to Homer caused by Carl's failure to complete the work. That sounds like a great answer compared to B, right? The bank can recover the reasonable value of the work performed by Carl, right? Because they're the assignee, and Carl was the assignor. But because he didn't complete 100%, Homer suffered damage of 25%, right? Because he was supposed to receive 100, but he received 75. So he suffered a damage of 25%, right? And he can argue whatever he has all the defenses he has against Carl, and that same defenses would apply to the bank, right? So he can argue, okay, you can charge me for the reasonable value, but I suffered damage, you know. And this fact pattern, they're just talking about 25, but in real life, he can probably ask for more, you know. The cost of hiring another a contractor, you know, the cost of finishing, and he can probably ask for that difference. But for the purpose of this question, C is the right answer. But let's look at D. Bank can recover the contract price minus the cost of completion of the contract. C is the better answer, right? Because it's more detailed, right? And I would definitely go with C over B or D. So C is the right answer here. Let's look at number 6. One night, Paul and David. One second. One night, Paul and David were having a heated argument in Paul's office on the 40th floor of an office building. David became angry and left, violently slamming the office door behind him. The force of David slamming the door caused the lock to jam, and Paul was unable to open the door or to leave his office until a locksmith came the next day. If Paul asserts a claim against David based on false imprisonment, will Paul prevail? All right, so this is one of those things where if you don't know the elements of false imprisonment, you're going to get this question wrong, right? So the fact that Paul is asserting a claim against David rules out that this is a criminal law question, right? We have party A suing party B. So what is this? This is a tort question. And what do you know about false imprisonment under torts? It's a intentional tort, false imprisonment. There has to be intent, right? Obviously, you're gonna have false imprisonment in a bounded area, and the person who's being imprisoned has to be aware. But first and foremost, it needs to be an intentional tort. So let's look at if this question's asking whether or not you know about this. A, yes, because Dave, David's act caused Paul to be confined. Well, I don't really like that answer. Act, causation? Well, without intent, act and causation doesn't really matter. Let's look at B. Yes, if David was negligent. Negligence. Negligence is duty, breach, causation, and damages, but we're not talking about negligence here. We're talking about false imprisonment. That's completely different. No, because Paul was in his own office. What does that have to do with this answer? That's just totally off. D. No, if David did not intend to jam the lock. Right. He slammed the door, but when he slammed the door, did he intend to confine, right, Paul in a bounded area? No. So obviously, his claim against David, I mean Paul, for false imprisonment won't fail for lack of having intent in one of the elements, right? So we got 6D. Let's look at 7 and 8. Husband and wife were staying at motel, which had a large swimming pool. A state statute required that owners of hotel and motel pools must, during the time that the pool was open for use and no lifeguard was present, post in a prominent place by the pool a sign of specified size stating, "Warning: no lifeguard present." Motel did not provide a lifeguard and did not post the required sign. One afternoon, wife went sightseeing and husband remained at motel. When wife returned, she learned the husband had been seen swimming in the pool and was later found drowned. There were no witnesses to the drowning. Wife suffered severe emotional shock when she learned of husband's death and had to be hospitalized under the care of a physician for several days. If wife asserts a claim for damages for the wrongful death of husband, the basis on which motel is most likely to prevail is, so we have a situation in a motel swimming pool, right? But they didn't have a lifeguard and they didn't have a warning saying no lifeguard present, right? If this was a negligence case, probably, you can prove it, but let's see if they're even asking about negligence, right? So let's see. If wife asserts a claim for damages of the wrongful death of husband, the basis of which motel is most likely to prevail is, so what's the defense that motel can raise in order to get rid of this lawsuit, basically? A. Husband assumed the risk because the absence of the sign and lifeguard was obvious. Huh. Assumption of the risk is awareness of a known risk but acting anyways, right? So this is, did he really know of the danger and did he act anyway? I don't really think so, right? It could be, but it's not great. Let's look at B. Husband was contributorily negligent in swimming in the pool when no lifeguard was present. The fact pattern doesn't really have anything about the husband doing anything wrong, that would lessen the what the wife would receive for damages. So that's not really a good answer either. Let's look at C. The absence of a warning sign was not a cause and fact of husband's drowning. This is a good answer. Like, more than the fact pattern itself, they ask a lot about this kind of question, right? Like, they want you to know that in order to disprove or prove a negligence case, obviously you can start with duty, saying that it's not a foreseeable plaintiff. You can also argue that there was no breach, right? But a lot of times, defense can argue that if plaintiff is suing you for negligence, defense can argue that there was no causation, meaning, you know, the plaintiff has to prove that but for the warning sign and lifeguard present, that drowning wouldn't have occurred, right? But since no one witnessed the drowning, right? How would you know that the lack of the warning sign or the lack of lifeguard present was the cause in fact, meaning but for causation? They're not even talking about foreseeability. They're talking about just but for. So that's the right answer because you can disprove this negligence claim arguing that you still haven't proved but for causation, and there could be other causes. It could be his heart. It could be something else, that caused his drowning, not necessarily, you know, the negligence of the motel. So C is the right answer here. But let's look at D. The statute imposed only criminal penalties for its violation. Well, we're not talking about criminal law here. So why is this even here? Are they talking about negligence per se? Negligence per se? I don't think so. So for 7, C is the right answer. Let's look at 8. If wife asserts a claim for damages against motel based on her emotional distress, will wife prevail? Well, they're talking about emotional distress, right? Is this an intentional emotional distress? Because, as you know, there are two types of emotional distress lawsuits. One can be under IIED, which is a intentional emotional distress, and the other one can be negligence, NIED, negligent emotional distress, right? So which one is this? Obviously, the motel didn't intend to cause emotional harm to the wife. So this would be talking about negligence, right? NIED, negligent infliction of emotional distress. And one of the things that you have to know about NIED is that the person who is suffering harm must be really closely related or must be present at the scene in which they've witnessed, heard, or either saw the accident that caused them harm. So let's see if they'll test you on this knowledge. A, yes, because wife sustained demonstrable emotional distress. Demonstrable emotional distress is not enough to prove an IED. That's wrong. Let's look at B. Yes, because motel violated a criminal statute. Again, that's like the same answer as number 7D, which is wrong. They're asking you for NIED, and what does criminal statute have to do with that? So B is wrong. C. No, because wife was not present when husband drowned. Yes, that's the right answer. I just told you for NIED, the person suffering harm must have witnessed, what caused them harm, you know, as a bystander. You can't not be in a kitchen when a accident happened outside, right? Because that, I guess you can make an argument that you heard it, you heard somebody scream. I guess that can be an argument, but ideally you have to have been there at the site of the accident and witnessed the accident as the bystander. But in this case, for this fact pattern, they tell you that no one was there when the husband drowned. So C is the right answer. Let's look at D. No, because wife did not suffer any physical impact. That's wrong. Because wife doesn't have to suffer as physical impact. for NIED. So the correct answer for A is C. All right, so let's just do three more. Okay. Frederick threatened Bruce with a physical beating unless Bruce personally wrote, signed, and mailed a letter to the President of the United States, threatening the President's life. Bruce complied. A statute makes it a felony knowingly to mail to any person a letter that threatens the life of the President of the United States. Is Bruce guilty of violating that statute? Well, what happened to Bruce here? He was threatened with physical beating, right? So when you're threatened for physical beating, if your life is in danger, you know, usually duress is a defense. Meaning, if you're under duress and you know, you're told to do something illegal, unless it was like a murder or a serious crime, it's generally a defense, right? In this fact pattern, he wasn't told to go and kill, right? They make that obvious. He was told to sign and mail it, which is a huge crime, right? But since he was under duress, is Bruce, who was under duress, guilty of violating that statute, right? Well, let's look at it. A, no, because he did not intend to take the president's life. Well, we're talking about duress here. When you read that fact pattern, you should know right away, okay, they're going to ask you about duress. So A is wrong. Let's look at B. No, because of the defense of duress. There you go. That's the right answer. If it was like a murder fact pattern in which he was duressed to go kill somebody and he killed somebody because of it, he would probably be criminally liable for that. But generally speaking, for duress to apply as a defense, it would be non-serious crimes like other than murder. And that's exactly what happened. So B is the right answer. But let's look at C. Yes, because duress is not a defense to such a crime. Well, this was not a murder. He was told to sign it and send it. So that would be a defense to such a crime. C is wrong. Yes, because Bruce was not threatened with loss of his life. Well, he was under significant bodily harm or injury, or he was about to receive, right? It doesn't have to be just loss of his life. So, what's the right answer? B is the right answer. All right, so let's look at 10 and 11 and finish off. If Frederick and Bruce are prosecuted for violating the statute and Bruce is acquitted, may Frederick be convicted. Right. Let's look at A. Yes, under the doctrine of transfer intent. Transfer intent here doesn't apply here. Let's look at B. Yes, because a person can commit a crime through an innocent agent. Yes. They love to test you on innocent agent, right? There was a fact pattern on the bar exam, baby bar exam. They tested on when a person told a kid to go steal something in his neighbor's house. It was a kid, but the person who told the kid to go commit larceny was an adult. And they asked you whether the person who told them, the kid, to go steal, can he be charged as a person who committed crime through an innocent agent? And this was a real baby bar question, and obviously, yeah, because he committed a crime through an innocent agent. So B is the answer here. But let's look at C. No, because Frederick did not write or mail the letter. That's wrong. No, because Frederick can only be vicariously liable for Bruce's act. No, because under the innocent agent doctrine, if he uses an innocent agent to commit a crime, he would be criminally liable. So for 10, B is the right answer. And lastly, let's look at 11. If Frederick and Bruce are charged with the crime of conspiring to violate the statute, they will most likely be found. So what's a conspiracy? Conspiracy is it requires intent to commit a crime and intent to agree, right? Two or more persons intending to agree, intending to commit a crime, right? And you can go off and about other details, but that's exactly what they're testing here. Whether or not two people here intended to commit a crime and did they have an agreement, and that agreement needs to be voluntary. And obviously, we can talk about like the Pinkerton and all that, but I don't think that's what they're asking you here for. So let's look at A. Not guilty because the conspiracy was merged in the completed crime. No. Not guilty because Bruce was not a willing participant. Guilty because Bruce participated in the commission of the crime. Guilty because Bruce complied with Frederick's threat. Well, the thing we talked about is whether that agreement was made voluntarily. And what happened here? The agreement to do something illegal was made under the duress of one person, right? So would there be a conspiracy here? No, because a conspiracy requires two persons voluntarily intending to agree and intending to commit a unlawful act. And B talks about that. B says no, because one person, Bruce, did not willingly agree to commit a unlawful act. So B would be the answer. So, wow, it's been almost an hour and 20 minutes. And as you know, these are not easy. But if you know the black letter law and if you really can read each fact pattern and kind of figure out what they're asking beforehand before actually looking at the questions, you're gonna have a good chance of passing this exam. And I'm not 100% refreshed on many of these because last time I looked at these three subjects were in June. It's been July, August, September, October, November. It's almost been like 5, 6 months, you know. But I'm just going by my memory because I've done this so many times, even though it's not perfect. But for the purposes of showing you how I arrived at each answer, I think it was helpful, right? So in my next video, I'm going to try to go over, another 11 questions and make, 5, 6, 7 of these videos so I can do all of them. So whoever wants to, go over these questions and kind of figure out how to, arrive at each answer, hopefully this video will be perfect for you. All right. So with that, again, I hope this video was helpful. If you have any questions or if you disagree with my reasoning, and I'm not saying that I said everything perfectly here. Like I said, it's been like 5, 6 months, and I have to kind of read over the outline again and refresh it in my head. But for the most part, I think I understood everything and kind of pulled out all the black letter law that was needed to solve these questions, right? So again, if you have any questions, feel free to leave a comment. If I feel like they're legitimate, I'll make sure to answer them. And if you need to find out where I got these questions from, it's from the bar website, and I'll also leave a hyperlink in the description so you can just click and study with these. And if you need explanations, hopefully these were helpful for you. All right. With that, thanks for watching, and I'll see you in the next video.